Hey guys, this video is the third part of the series on contract formation. Today we are going to talk about acceptance of an offer. What is acceptance? According to Tritle on contracts, an acceptance of an offer is a final and unqualified expression of assent, that means consent, to the terms of an offer. Okay, this was endorsed by the Singapore Court of Appeal case in Gay Chun Ing and Lo Si Si Terence Peter. Acceptance of the terms offered by the offeror, that means the person making the offer, has to be unconditional and unqualified. The offeree, the person receiving the offer, cannot add new terms, cannot make counter offer, variations, conditions of the original offer, because any variation or a counter offer will destroy the original offer. Let me give you an example. In the English case of Hyde and Wrench, Wrench offered to sell his farm to Hyde for £1,000. Hyde responded that he will only pay £950 for the farm. Okay, this offer was rejected by Wrench, the seller. Okay, so Wrench offered to sell the farm for £1,000. Okay, instead of accepting, Hyde, the buyer, said no, $950 only. Eventually, on a later date, the buyer later accepted the original offer of $1,000. Okay, which the seller Wrench rejected again. The court held that there was no agreement between the parties because once the buyer rejected the original offer by submitting the counter offer of $950, the counter offer of $950 destroys the original offer. So even though later he decided to accept the original price, there was no agreement because the original offer was destroyed by the counter offer. Second thing to take note of, the acceptance has to be communicated to the offeror, the person making the offer. It has to be either written, verbal, or by conduct. So if the offeror did not hear the offer, for example, there was this case, for example, if the offeror was standing on one side of the road, the offeree was standing on the other side of the road, and then a plane flies across the road, and the offeree says, yes, I accept your offer, but the offeror did not hear it because of the plane. So there's no acceptance of the offer because acceptance was not communicated to the offeror. The exception to this would be the postal acceptance rule, which is an outdated rule. Nowadays, hardly anyone uses post. We all use email. So, whether an acceptance has in fact occurred is determined objectively from the behavior of the parties, including any correspondence that has passed between them. This principle was laid down in the English case of Inland Revenue Commissioners and Fry. The facts of the case were this. The Inland Revenue, was going after Mrs. Fry for £113,000, in income tax. So there were negotiations between Mr. and Mrs. Fry with the Inland Revenue, basically the tax authority. There were negotiations between them to reduce the tax bill. Eventually, Mr. Fry, the husband, sent the Inland Revenue a check for $10,000 with a cover letter. The cover letter stated that this check is in full and final settlement of the debt due from Mrs. Fry to the Inland Revenue. The cover letter further stated that the offer to settle the amount of accrued income tax at the lower amount of £10,000 could be accepted by presenting the check for payment at the bank. So, in accordance with internal procedures, the Inland Revenue presented the check with the bank. The court held that there was no acceptance of the offer to settle the tax bill at the lower amount of £10,000 for the simple reason that the Inland Revenue receives thousands of checks every day, okay? And it was standard operating procedures to cash the checks, to bank in the checks, and that it was highly unusual for a check to be accompanied by a cover letter like this, so it could not be taken as an acceptance. So thanks for watching this video on acceptance. Stay tuned for the other videos on formation of contracts.